Morning, everybody. I'm still not used after COVID to the idea of sitting in a room on my own and speaking into a laptop, knowing that there are however many number of people there are out there listening in. But you'll have to forgive me, I'll do my best. This is the latest in the King's Chamber's commercial litigation webinar series on remedies for fraud, damages for fraud. Although that's a bit of a misnomer in itself. The good news, well, it depends if you think this is good news or not, is that I'm very unlikely to talk for full 40 minutes because the scope of the seminar is so narrow that it becomes difficult to see the wood for the trees if you get in, I think, into too much authority and all the rest of it. It's a bit like saying to somebody, we'd like you to do a 40-minute seminar on the Old and New Testament. What I want to try to do, based on my experience in practice, is to give you a short address on the basics of the sort of remedies you come across in fraud-type cases. And again, without bombarding you with authorities, to try to give you the fundamentals of the subject. Because my experience is that what often goes wrong in practice is that there is a confusion over the basics, and it's important to get those right in order to effect and manage a piece of litigation effectively. One further observation on that I've picked up on is that you can often tell quickly from a reading of the other side's case, whether that's in a pre-action letter or in pleadings, whether or not you think the other side properly understand the law on it, often by reference to the terminology they've used. So it's important to try to get the terminology right. So what I'll do is, in short, is I'll come to the two areas I want to look at. The two main areas are remedies for breach of fiduciary duty, where there's a fraudulent element in the alleged breach. And I want to look at also accessory liability, by which I mean remedies for knowing receipt and remedies for dishonest assistance in the commission of a breach of trust. There are others, but they're the lesser spotted variety, and I don't want to get into confusing what is quite an involved subject already. A further piece of good news is that I'm not going to share anything on screen. What I propose doing, and this is the usual way I approach these things, is to circulate a paper afterwards, which will contain everything I've said and a bit more, and it'll also have case references in it, so that you don't have to battle now with trying to remember citations and all the rest of it. So just for now, sit back, relax, and I'll try and lay it all out for you as best I can. I want to start by just looking at the concept of fraud itself, because fraud can be a confounding concept for the commercial litigator. The basic reason for that, I think, is that fraud is notoriously difficult to define in itself. Put it another way, people don't do fraud, so there isn't a specific wrong which we label as fraud per se. That there may be in the criminal world, but in the commercial world there isn't. What has happened is that the common law and equity have developed their own ways of reacting to a type of behavior, which is what we're really talking about when we talk, that's the mood music with fraud. We're talking about the type of behavior or the way in which somebody does something. And it's that colours it with fraud. And we're not necessarily talking about out-and-out dishonesty. It's possible, for example, to have what we call a fraudulent breach of fiduciary duty without the requirement for dishonesty. mean, for want of a better description, it's a bit like an elephant. It doesn't matter if you haven't seen one before. You'll know it when you see it. So fraud's a notoriously difficult concept to define. And what I want us to bear in mind from the outset is that the way in which the common law reacted to fraud was really based on the contractual model. Typically, a contractual statement made for the purpose of deceiving, on which the courts developed remedies, the principal one of which is common law damages. Equity is far more flexible than that. And when we're talking about fraud in the context of equity, there are no such constraints. And really what we're dealing with when we talk about fraud in the equitable world is typically, ordinarily, is breach of fiduciary duty and the remedies that are available for that. And that also involves, I'll just put a marker down, that also involves in its development the intrusion of the constructive trust, which is part and parcel of that. Before I go any further, I just want to remind you of a couple of pieces or sections from the Chancery Guide. And you might say, well, we're not really too worried about the Chancery Guide because it's counsel that should be concerned with that. But the reason for doing this is that everybody on the team should be alive to two things. The first is the statement of case and what should be contained within the statement of case for the purpose of identifying the cause of action. Because there's nothing worse than reading a pleading. You're reading it thinking, well, where is this going? I don't see what the action is. And I want to just draw your attention to a section of the Chancery Guide that talks about pleading fraud. Well, it talks about setting out allegations of fraud, but I just want to remind you what they are. So the purpose of a statement of case, first of all, these come from a case, they were summarised in a 2021 case called King and Stiefel. It's a High Court case. It's a case in the Commercial Court, Mrs. Justice Cockrell. And she says there are three functions that a statement of case fulfills. First of all, the statement of case enables the other side to know the case it has to meet. Secondly, the statement of case ensures the parties can properly prepare for trial and that unnecessary costs are not expended in court time chased requiring points which are not at issue or which lead nowhere. And the third is the process of preparing the statement of case operates, or it should operate, as an audit for the claimant or defendant in its legal team that it has a complete cause of action or defence. And it's the third of those that I highlight. For the purpose of pleading, it's desperately important, at the risk of a strikeout application, to ensure, particularly when one is pleading fraud, to ensure that one has all of the essential elements of the cause of action pleaded. I mean, it's possible, I've seen this, I'm sure everybody has lots of times, to see almost poetic pleadings, which are beautifully phrased, but which on closer analysis don't contain everything they should contain for the purpose of making good on the cause of action that's being advanced. I'd pick up on that third point, the requirement for the audit, if you like, of the cause of action. Let me just remind you what he said about allegations of fraud. Harking back to what the CPR has to say, the relevance is, it's in Practice Direction 16, it's paragraph 8.2. That requires that where there's an allegation of fraud, the parties have to ensure that they state full particulars of any allegation of fraud, dishonesty, malice, or illegality. That's the first thing. And secondly, where any inference of fraud or dishonesty is alleged, the facts on the basis of which the inference is alleged. But what you can't do is stick down a long list of conduct on the part of the defendant and then say, and all of the above were fraudulent. Well, that ticks the box, so we're okay now, we can carry on. Not so. You have to be able to say confidently why. Well, first of all, you've got to say confidently that the particular acts, as you've broken them down, are fraudulent, and then say why. And just before I carry on, let me then just remind you what the Chancery Guide says. A party should not make allegations of fraud or dishonesty unless there's credible material to support the contentions made. Setting out such matters without such material being available may result in the particular allegations being struck out and may result in wasted costs orders being made against the legal advisors responsible. So it's with an allegation of fraud, you're playing with fire. And I've had this, certainly since I took silk, I've been involved in far more cases involving fraud than I did previously. And one of the things I've found is there's a natural disinclination on the part of some people to want to proceed with a fraud claim. In a way, it doesn't matter how one feels about it at an instinctive level. You've either got the material you need in order to plead the fraud claim, or you haven't. And if you haven't, you can't do it. The idea is there's a number of authorities that say that counsel actually is the sieve that should tease out those cases which shouldn't be advanced as fraud claims. Mr. Justice Patton, in particular, talks about that in a case in the last 10 years, the name of which I can't recall. But it's important that you are able to confirm to yourself before you move on. And sometimes it's necessary to sense check this between the team, that you actually have the material in order to be able to proceed with the fraud claim. It's sometimes possible that you amend to add an allegation of fraud once you get further down the line and once you've got disclosure, because it's that will often give you what you need in order to be able to substantiate the fraud allegation for the purposes of what the Chancery Guide reminds us of the prerequisites. So that is a general introduction to by way of background. And you may say, well, what's that got to do with remedies? Well, the first thing it's got to do with remedies is, in order to plead the case properly, you need to be able to say confidently what in the prayer and in the part of the pleading that sets up the claim for relief. You need to be able to say what the remedy is. In order to do that, you've got to be able to plead the case properly. There's no point in pleading a case and then saying at the end, well, here's an old chestnut, just saying, well, it must be damages. Let's just put damages down. I mean, damages is often the giveaway. You think, well, they don't understand the cause of action for breach of fiduciary duty. So I start with that because it's important to be able to plan the claim, and it's important to be able to say absolutely confidently what the relief sought is. Not least because if you don't plead the particular relief you're after, although you might say further or other relief and find yourself at trial saying, well, yes, we know we said that in the pleading, but we actually want something else. It's best to be able to get it out at the front end and say specifically, that's the relief we want based on what proceeded in the pleading. So let me move on from there to remedies for, first of all, I think it's the most common form of fraud claim, breach of fiduciary duty. Now, there are three basic remedies for breach of fiduciary duty. And if we had more time, I might say, well, go on the chat or Q&A function and let's have a go at seeing what those remedies are. But ask yourself this, do I know what the remedies for breach of fiduciary duty are? The answer is there are three, and I'm not particularly concerned about the third one. The first is equitable compensation. You may say, well, it means damages, doesn't it? I don't. I mean equitable compensation, and it's not the same thing. There are differences between common law damages and equitable compensation that I'll come to shortly. But the remedy is equitable compensation. The second is the provision of an account, and one and two often go hand in hand. So the account informs the value of the compensation, the equitable compensation that's claimed. But just whilst I'm on referencing the account, let me just remind you, it's always good to have in mind, or at least be familiar with, or have looked at, Practice Direction 40A in the CPR that deals with accounts and inquiries. It's only a short section, but it gives you the nuts and bolts of what an account and inquiry involves for the purposes of that form of relief. The third form of relief is restoration of property. I mean, that may be obvious, but I'm not going to say a great deal about a claim where what the claimant says is primarily I want the property back. If it's perhaps unique or idiosyncratic in some way, the claimant says damages will never be sufficient in order to recover its loss. So we want the actual asset back. And there's no problem with pleading all three of those simultaneously if the facts justified it. So the claim the types of remedy you'll see there are claims or remedies which are actionable against trustees. And within trustees, I include company directors, but they're claims essentially that are actionable, against fiduciaries. And directors, trustees are within well-established categories of fiduciaries. The class of fiduciaries is not a closed class, and the facts of the case may throw up a relationship which the parties are capable of arguing is capable of falling within the definition. There isn't a definition within what the courts have said constitutes a relationship, a fiduciary relationship. The best case for that still, I think, is Mr. Justice Millett in Bristol Building Society in Mothieu, 1996 case. So what that says in effect is if it fulfills the characteristics of a fiduciary relationship, it's probably a fiduciary relationship. And most typically, that involves one party being responsible for the management of a piece of property that belongs to another party. And you see how that works with the company and its property. Even though directors are treated as trustees, they're not trustees, but they're treated as trustees because they tick all the boxes for fiduciaries. That's J.J. Harrison against Harrison. That's Mr. Justice Chadwick in 2003. I'm involved in a case at the moment where the claimant is a mortgagor and the mortgagee, at first it looks like a typical mortgagor-mortgagee relationship, but in fact the mortgagee joined into a joint venture with the claimant as mortgagor and took responsibility for the development of a piece of property that belonged to the claimant. And part of the argument that's being run in that case is that, in fact, the mortgagee is not just a mortgagee. It is also a trustee and has fiduciary obligations to the claimant as mortgagor, but in its capacity as beneficiary of that fiduciary relationship. So joint venture arrangement isn't within certain categories of fiduciary relationship, but if the facts fit, then the court will impose those obligations. Equitable compensation, as I say, is not damages, but it is concerned. But it is similar to damages in the sense that the fundamental underlying principle is the restoration of the value lost to the party bringing the claim, where the loss has been caused by the breach. In other words, applying a but-for test where the loss wouldn't have been suffered but for the breach. So it's the loss to the claimant. It's not the benefit to the defendant. And once the breach of duty has been established and the claimant is able to demonstrate that it sustained the loss, that the burden then shifts onto the director, who has the onus of establishing that the loss would have been incurred in any event, notwithstanding the breach. Now, I said earlier, well, let me just give you an example of that. Probably the paradigm case or example comes from a case called Gwenby Valley, which is a Court of Appeal case in which Mr. Lord Justice Mummery referred to misapplication of company property by a director, where the misapplication is without authority and where the misapplication is for the purpose of the personal interests of the directors and not the company. In a case like that, the company is going to have a claim against the fiduciaries for the loss that's been incurred as a consequence of the conduct on their part. I said earlier that you may say, well, this sounds very much like damages to me, although I think he said earlier that equitable compensation isn't damages. Well, it isn't. And the relevance or the key distinction between the two is that the common law concepts of causation, foreseeability, remoteness of damage don't apply to equitable compensation. So when you're pleading a common law damages claim, you have to deal with causation, foreseeability, and remoteness, depending on the particular facts of the case, because or at least you will have to address those in any event on the law when it comes to trial. None of that applies in the case of equitable compensation. Now, that leads to the temptation to say, well, let me get this right. If you're claiming loss and you take out causation, foreseeability, and remoteness, does that not mean that the claimant can just claim anything and simply say, well, I suffered this enormous loss, and because you don't consider those concepts, I'm entitled to claim it all? The answer is no. That's because what the court does is it applies something in the alternative to causation, foreseeability, and remoteness, which is a far more flexible concept of hindsight and common sense. That comes from a number of cases, but the judgment of Lord Brown-Wilkinson in Target Holdings AIB and Target Holdings is a very good, it is an excellent exposition of how that works. So in other words, it allows the court to apply hindsight and common sense and to say, applying a but-for test, these losses would have been incurred, but those wouldn't. It's just an alternative, but far more flexible concept than those concepts that apply to common law damages. And there's a case, an Australian case called Maguire and Macaroni with a K, in 1997, which I often think puts this very neatly in the following terms. Equitable compensation is a far more flexible concept than damages. They will be fashioned according to the exigencies of the particular case to do what is practically just as between the parties. The fiduciary must not be robbed, nor must the beneficiary be unduly enriched. So that in a nutshell is what I'm trying to convey when I talk about the concept of equitable compensation. Just a small practical point with directors. Directors are jointly and severally liable for breach of fiduciary duty. It's an old case, an 1894 case called Land's Allotment. But I seem to get asked this a lot as to whether or not the directors are all liable or not for the breach of one party. And finally, interest. What is particularly attractive with a claim for equitable compensation is the interest basis. It was a very good explanation in the narrative of Lewin on trusts. And that explains the basis on which the courts have developed the concept of awarding interest on a compound basis with yearly or half-yearly rests in the case of equitable compensation. Now, that compound interest, I often say, is the eighth wonder of the world, but I was involved in a case that went to trial in 2023 where we succeeded, the claimant succeeded, and where we'd issued just before limitation, and where we got home on almost everything in the claim. And the interest was almost as much as the principal sum on the equitable compensation claim. Two were about the same. It was an enormous amount of money. Depending on what interest rate, obviously, you apply. But even applying in that case, what I recall was 1.5%, for what in fairness was pretty egregious conduct on the part of the director, two directors, was a huge amount of money. I just want to, before I leave equitable compensation, talk about accessory liability. Let me just say, it should be apparent from what I've said so far, but let me just pin this down. The assessment of damages is fixed at the date of the hearing. So and with the court looking back to what's happened previously, but it's fixed at the date of trial. And in a lot of, well, I say a lot of cases, in some cases, the case I've just mentioned, for example, where we had a split trial, the court viewed and assessed the damages as at the quantum trial at the back end of that year, 2023. And just for completeness, mitigation applies equally to equitable compensation, perhaps unsurprisingly, as it does to common law damages. In other words, the claimant can't get home in terms of loss for losses which it could reasonably have avoided by taking steps to mitigate his loss, by taking reasonable steps to mitigate his or her loss. That's a whistle-stop tour of that area. But that is, when we're talking about fraudulent breach of fiduciary duty, that is the basic rundown of the way in which damages, equitable compensation is calculated. Just with an eye on the time, I just want to say something briefly about accessory liability, which is in commercial cases is as common, perhaps not as common, but it's one of the major forms of relief that one sees in commercial cases. And accessory liability is the generic term I apply for, first of all, knowing receipt or knowing or unconscionable receipt. And then secondly, I'll just mention remedies for dishonest assistance. Just by way of reminder, in terms of knowing receipt, there are three, you'll know this already, but I'll just mention them. There are three essentials for a cause of action for knowing receipt. The first is disposal of assets in breach of duty. So in Paradox case, if you look at directors misappropriating assets or paying them away to a third party, you then need beneficial receipt of the asset by the defendant, where the asset is traceable, because it doesn't matter if it's moved on from the defendant, but it's traceable as belonging to the claimant. And the third requirement is knowledge on the part of the defendant that the transfer is in breach of duty. Now, the law of trusts, again, has intruded in this area and lent itself to language in some of the authorities, which is not helpful. But the best description of the remedy for knowing receipt is, if we talk about personal liability to account, that's on the part of the defendant. Account for what? Well, it's to account for the value of the benefit received. And as I say, it doesn't matter if the defendant has divested himself of the property, the money or the property. Liability still attaches and can go on to attach to the recipient from that party, subject to the recipient from him or her, knowing that the money is being paid away in breach of duty. But the measure, the primary measure, is the value of the benefit received plus interest. That leaves me with dishonest assistance. Now, dishonest assistance is slightly more complex in terms of the cause of action, but what's required for it is a trust or fiduciary relationship where the relationship is breached, where there's no requirement for the trustee or fiduciary to be dishonest, but the requirement is that the third party has induced or brought about the breach, and there is a requirement that the third party has acted dishonestly in providing that assistance. So one is looking with dishonest assistance not at the mind of the fiduciary who is responsible for paying the money away, although they may be dishonest. One is concerned with the state of mind of the assistor who brings about the breach of duty. And the remedy again is that gives rise to a personal liability to account on the part of the assistor for the loss which is suffered by the fiduciary as a consequence of the loss that is suffered by the beneficiary, in the company case, the company, as a result of the assistance being rendered. And it's important to bear in mind as a cross-check for that the remedy against the assister is exactly the same as the remedy that will be available against the defaulting trustee. And the measure of loss will also be the same. I'm going to stop there because because you'll thank me for this. If you've not already felt as if you've died and are in purgatory, the next section is on conversion. But I'm loath to get into it, other than if you're particularly interested in it or it's arisen in a case, look at section 3 of the Tort Interference with Goods Act 1977, which explains the calculation. It's a formula for the calculation of damages in a conversion case. And that references the value of property at the time of the conversion. So something of a whistle-stop tour through the areas of covered. And as I say, I'll circulate a paper that deals with that. But my overriding concern was seeing the wood for the trees and not getting lost in a mass of authority. I've mentioned some cases briefly in passing, but I'll include further elaboration on those in the cases. Thanks for tuning in. I hope that's been of use. And like my colleagues, I'm always happy to talk anything through, anything to do with law, obviously, and ideally commercial law. Thanks very much. Thank you.